Hi everyone, let's get started. So I'd like to start by welcoming everyone to this panel event titled AI to Zero Day, the Changing Risk Profile of Technology Products and Services, brought to you by the Australian Society for Computers and the Law in partnership with Willis Towers Watson. Now, before I formally kick things off, I'd like to firstly acknowledge the traditional custodians of the various lands on which we meet today. I would also like to acknowledge the Aboriginal and Torres Straits Islander people participating in this webinar. I would like to pay my respects to the elders past and present and emerging, as well as recognize the diversity of Aboriginal and Torres Straits Island people and the ongoing culture and connection to the lands and waters of New South Wales, Australia. My name is Delvin Chen, and I'm a partner at Spark Elmore, where I lead the technology law, focusing on technology transactions and data security. To put it quite simply, I basically help clients buy, sell, and get the most out of their technology. I also help clients understand and navigate their way through the legal complexities of data. Now, I've been doing this for quite a while now. I've been doing this for well over 18 years. I should note that the entirety of my Spark Elmore team should be here. I know they're closely watching the slow introduction and looking for my verbal tics. Hello, team. Now, what makes me slightly different, I think, and what drew me to the society, ultimately it came down to this. At any one time, I wear three hats. My private practice hat, where I act for a range of clients and through that stay on top of the future of technology and technology contracting. My industry experience hat, through my roles where I've been embedded in a number of major organizations in government, banking, technology, and health. And finally, my academic hat, which Benjamin shares. I've been lecturing and convening a Masters of Law course on commercial drafting and information technology law at the Australian National University. Now, similarly, the Society also wears a number of different hats. The Society is a leading think tank whose purpose is to advance education and advocacy at the intersection of technology, law, and society. The Society prides itself on being interdisciplinary and draws its knowledge from a range of areas, including law, industry, government, academia, and society. Its membership base comes from these diverse sources, thus allowing it to engage in meaningful and learned discussion and debate, which, as we all know, is becoming an increasing necessity in the evolving world of technology that we all live in, or at least have expressed an interest in. We have an amazing events program, of which this is one. So now, tonight's event is about technology products and services. I think this will be a great session. The panelists will discuss and get prodded on the risks inherent in the supply and procurement of technology and explore the changes to these risk profiles. They'll look at this in the context of the product and services itself, as well as the continued threat of cybersecurity incidents. The session will be moderated by Benjamin DeMarco, who will also introduce the panelists. Ben is a technology, risk, insurance, data, privacy, and dispute resolution expert with over 14 years of experience as an admitted solicitor. He has practiced in both Australia and in the United States. He currently leads Willis Towers Watson's cyber risk advisory, analytics, and insurance services in Australia and New Zealand. His work focuses on helping clients understand their data security exposure and tailoring resiliency and support solutions to match their needs. Like me, Ben is an academic and is a university guest lecturer with the Queensland University of Technology. He's a National Cyber Risk and Governance Lead at the Australian Society of Computers and Law and is also a member of the Queensland Law Society Data and Privacy Law Committee. Now, before I hand over to Ben, a few reminders. A reminder that the session is being recorded. A reminder, too, that following the panel discussion, there will be a live Q&A. Please ask your question in the chat box at the bottom of your screen. It would help us a lot if you could, if you're comfortable, provide your first name, the organization you represent, and who your question is directed at. Without further ado, over to you, Ben.
Brilliant. Thank you very much, Delvin. And to echo Delvin's message, This is a topic that myself and the team at Willis and also the AUSCL have been very excited to explore for a long time. Technology products and services has occupied a slightly unique space, particularly in the Australian risk landscape. There's a huge amount of trust and responsibility that we place in these entities. And what we're hoping to do here is try and distill some of the elements that form part of that trust, so the changes they see with innovation, the regulatory position, how they're engaging with clients. I'm incredibly thrilled to be joined by an expert panel, and one of the great things about this panel is we've got very, very good cross-functional and different points of view on the industry. To briefly introduce our panelists, I'd like to start with Petra Lucioli, who is the Claims Manager and also a Director with Delta Insurance based in Auckland. Delta is the largest insurer of technology companies and technology risks in New Zealand. Petra has over 20 years of experience in claims management. She is an admitted litigation lawyer and has practiced in the UK. She spends a huge amount of her time handling complex professional liability and other claims on behalf of tech providers. One of the reasons we're very excited to have Petra here is, in addition to her claims expertise, she's someone who's committed to understanding the technology risk space and working with her clients to help them not just in terms of the legal claims and disputes they face, but many of the other wider and emerging trends. I'm also joined by Angela Flannery, who is a partner with Holding Redlich and sits within their corporate and commercial group. She has over 20 years of experience as a partner and also working in senior roles with Australian Commonwealth Government entities. She has broad experience in transactional and regulatory matters and has a strong focus on telecommunications, media, technology, privacy and cybersecurity. We also have Nitesh Patel on our panel. Nitesh is a special counsel and soon-to-be partner, which I believe we're allowed to say, at Gilchrist Connell, who specialises in cyber risk and technology. He works closely with his clients to help them avoid the pain that can be caused by catastrophic cyber events and also in terms of defending and managing technology disputes. His work also extends to proactive work across risk management in the privacy and security obligation space and also in terms of drafting agreements and work towards the front-end process by which organisations engage technology providers. The last person we have in our panel is Nick Ferret QC. Nick is a barrister with deep expertise in commercial litigation who's conducted trials in the Supreme, District and Federal Courts all throughout the country. He has a very broad area of expertise, which includes contract disputes, employee and restraint of trade, negligence claims, economic loss disputes, misleading and deceptive conduct, defamation, company law, shareholder oppression, insurance and urgent interim relief. So it's fair to say most of the terrible things that can happen to technology companies and their providers, he's either seen or been directly involved in. So that may be a discussion for later on in the talk. So that sets the introduction. What I'd like to do now is start throwing over to our panel. And the first question that I want to create is looking at the terms that we put in this topic here. So again, we've talked about this as being an examination of technology products, technology product providers and technology services. So Petra, I'll ask you first, what do the terms technology products and technology services mean to you?
Okay, thanks, Ben. I probably come from a slightly unique position here because the terms actually have a very, very specific meaning for me as an insurer because they're defined in the insurance policies that we sell. What I would say about that is that the question that you've asked is actually very relevant to why technology insurance policies exist, in that the distinction between technology products and services is something that caused a lot of difficulty. In that, typically technology products, well, it's basically computing, electronic, and telecommunication technology that's used to distribute information is the way that I would look at it. But the distinction between a technology product, which might well be a piece of hardware but could equally be software, and technology services, which typically would be advice but equally could cover software, makes the distinction between the two quite difficult. And so if you have a company which is developing software, whilst it's carrying out that development, it's providing services. But once it's in fact delivered that software then becomes a product. And so there's quite a lot of overlap between the two concepts. And one of the reasons for the creation of a bespoke technology liability insurance product was to deal with the fact that most professional indemnity policies couldn't cope with technology products and with that overlap with the services that were provided. So for me, that's really the distinction. There is overlap, but there's the provision of service, and then the physical and software elements.
Nitesh, as someone who sees these disputes in a few different lenses, do you have any comments on what technology products and technology services means in your perspective?
Yeah, thanks, Ben. Look, it's kind of it's almost on the other side of what Petra just mentioned, and that's effectively we see it from the claims side itself, and we interact directly with the insured under those policies, and we've seen a real expansion of what once was considered a technology services company or a technology service provider or a technology product provider. And so you've got your traditional software developer or hardware company, telecom or media companies as well. But then you've got things like e-discovery providers. You've got business support services companies that are now coming into that concept. So the concept is now getting fairly broad, and I think it's going to keep getting broader just because the reality is for many businesses is that even if their core business isn't technology, because of the extent of their reliance, some parts of their business effectively could be seen as a technology provider. So it's increasingly broad as a concept, I think.
And I'll just make one comment echoing that too. One of the challenges we see a lot for particularly a number of our clients is what we understand to be a technology service or product is subject to innovation. So there's a lot of things now we see specifically in the cybersecurity space where software and advisory didn't exist 5 or 10 years ago. We're seeing the same with medtech. We're seeing the same with some of the regtechs. So I suppose that's the other challenge too, in that you can never have a confined static definition. It's always going to be subject to evolving. Angela, I'd also like to throw to you just to get your perspective.
Thanks, Ben, and hi everyone who's joined the webinar today. So I really only have a few things to add to that. So I agree totally with the comment you just made, Ben, that it's an ever-expanding list of products and services that fall within those broad categories. And I think that is part of just the evolution of technology. But, you know, one common, or one example of that where, you know, technology has sort of invaded a space that would typically be considered technology-free would be in the context of advertising campaigns. So when an enterprise hires its marketing agency for an advertising campaign, typically they wouldn't see that marketing agency as providing a technology service, but actually typically what they're acquiring through that agency is a technology service, not only because most advertising now is done digitally, but because technology services, as Petra mentioned, involve the use and exploitation of data. And that's what ad tech services do in that context. They use data to more accurately target advertising. So it is very much an evolving field.
That's a really excellent point, and well, we'll come to it a bit later. I think you gave a great example of why the regulatory piece and the legal piece struggles to keep up, because ad tech is almost a bit of a dirty word at the moment, whereas 5, 6 years ago, no one really cared. With that in mind, Angela, I'll throw the next question over to you too, which is looking at the boundary of what's happening with technology products and services. Is there one or two key or significant challenges that you see at the moment?
Well, yes, it's a good day to have this session, because obviously very recently we've had another ransomware attack hitting the front page of the media here in Australia. So clearly, you know, cyber risks are one of the challenges for product and service providers. So we had a significant incident over the last couple of weeks. So JBS, a meat processor, a global meat processor, was impacted by ransomware, and its Australian operations were effectively shut down. And you might think, oh, well, meat processing, that's not too bad. But actually what happened was that impacted 47 sites, and in fact 11,000 employees were stood down. So that really indicates how significant those ransomware attacks could potentially be. And of course, it also turns out that that particular ransomware didn't only affect JBS, but impacted a number of other Australian companies. And enterprises really do look to their technology product and service providers to help them deal with ransomware. So cyber incidents, clearly a significant challenge to deal with those. But also, given I'm a lawyer, unsurprisingly, I'm going to say that regulation is a significant challenge as well. And there's one thing you can say about practicing in this area is it's never dull in terms of what new regulation is coming along. But one example I wanted to give of that just demonstrates the challenges that technology, either product or service providers face, is the proposed amendments to the Security of Critical Infrastructure Act that were introduced by the government late last year and are currently being considered by a parliamentary committee. So at the moment, the Security of Critical Infrastructure Act is quite a boring little act, so to speak. It impacts only electricity, gas, water and port sectors, and it imposes quite a limited number of obligations, largely around reporting, ownership and the like. But what the government is proposing is to amend that legislation to significantly increase the number of sectors that the Act could apply to. So it's drafted this bill that's got an expanded number of critical infrastructure asset classes, and once you're in the bill, assuming it becomes law, if the government makes a rule in relation to your critical infrastructure asset class, then you'll be subject to an enhanced range of obligations under that Act, which include having particular policies in place to manage risk. And there are two categories that are particularly relevant to the technology type sector that are included within that bill. The first category is communications, and many of you may wonder why that wouldn't have been in the Act in the first place, because communications are obviously equally as important as ports and the like. But actually telecommunications has its own regime in the Telecommunications Act that deals with the same sort of issues that it's dealt with in the Security of Critical Infrastructure Act. And so arguably they don't need to be subject to this regime as well. So what the government's decided is that they are so important for the functioning of the economy, and also contain such large amounts of data, that they create a national security risk, and it's probably better to deal with them in this Act rather than the Telecommunications Act. But the other category, which is also really very interesting, is data storage or processing assets. So that is intended broadly to cover data centres and cloud services. So it won't pick up every data centre, but it will pick up data centres that where the provider of the relevant service knows that they're storing or processing business critical data. So things like personal information of 20,000 or more individuals, information relating to systems needed to operate critical infrastructure assets of other types and the like. So if you fall within those categories of critical infrastructure assets, if a rule is made in relation to that class, then you will be subject to this additional regime. And so that's likely to impact many technology providers, either services or product providers, in a way that they haven't been impacted before, and will be a challenge that they'll need to meet.
Thanks, Angela. Nitesh, I suppose from your perspective, do you see any other significant challenges for tech products and service providers?
Yeah, look, I think to echo very, very briefly what Angela has just said, the cybersecurity generally is a real focus, simply because of the media and the publicity that you see around those issues, but also the greater exposures that we're now seeing as a result of it. I think a particular point I wanted to make is that threat actors themselves are becoming more sophisticated and targeted, and they're looking for the greatest payday with the minimum amount of fuss, and so tech providers tend to be in an area of focus for them, simply because compromising a tech provider can often lead to the compromise of multiple other targets. And I think a simple example would be what we're seeing with Accellion, unfortunately. So that's a real one of focus at the moment for many tech providers. Supply chain risk is another one, and that's as a result of globalization and the increasing specialization of businesses. There's a real reliance on supply chain to deliver components and of various products and services on time and as specified. So making sure that's all in place and making sure you've got the proper processes in place is really important. And as soon as one of those things falls down, that can lead to other issues. And that also ties in again with the cybersecurity piece, because in amongst all that, you want to make sure things are on time, and to spec, you want to also make sure that all the various bits and pieces are in place to make sure that whole chain of command is secure. So there's that. The speed of innovation and evolving demand is another one that is coming up a fair bit, and it's simply that the speed at which new products are being released to market is driving increased development speed, at times unsustainably, and so there's this greater push to try and deliver to market something that's newer, better, bigger, brighter, when it may not necessarily be ready for market, and that's again leading to some issues and some headaches. And then just the greater general reliance on technology has meant there's more entrants, there's more clients, and they have varying degrees of sophistication. So if you're a technology provider that's used to supplying products and services to a more sophisticated client who understands the process or understands the risks and how things can evolve and change over time, and then use that same approach with someone who's relatively new into the space, that can lead to a number of issues. And finally, tying in with all of that is also the regulatory risks that Angela mentioned. I think she's gone through that in some really, really good detail, so that's excellent. I think the other piece around that is seeing how that ties in with other jurisdictional risks and some of the implications that can have is also a big thing. So that particular legislation Angela referred to may cause some headaches for a couple of internationals around their other obligations that they might already have. And then, of course, I think we'll touch upon this a bit later, the CPS 234, which is already in place, and those obligations on APRA entities are being pushed down through the supply chains, including IT providers.
Petra, did you have anything that you wanted to add?
Yeah, probably just two points that develop slightly on what Nitesh has been saying. The first is probably one of the biggest things that I tend to see is an increasing mismatch in the contractual terms down the supply chain. And that is something that's definitely getting worse as the bigger players at the top of the chain are imposing stricter and stricter terms and more restrictive liability on their own part. And there's then a mismatch, between that and and the technology provider in the middle, who can then only only put terms to their clients that their clients are prepared to accept. And and the smaller technology firms are certainly ending up taking on a lot of liability that actually rests with potential errors and omissions at the top end. So that's certainly a big and growing problem. And the other one, it's in the cyberspace, but what I'm beginning to see is a bit of a variation on a theme. So there are, of course, all of the the obvious cyber risks, both directly for the firms, but also in terms of making sure that that their products are secure and aren't subject to malware. But what I've been seeing is a bit of development in the in the area of privacy laws. And I'm thinking, there's a particular example I have where a claim arose out of strengthening privacy laws, where we had a software developer who developed a loyalty app for a shopping centre. The issue that was discovered was that it accessed the phone on the camera on people's phones. And they discovered that an error in the programming caused that camera to remain on when the phone was when the app was closed, and the result was that the local regulatory authority investigated and charged investigation costs and a fine to the company that was using that app for that privacy breach. And so I think that's a sort of development beyond just your standard cyber claim developing into a ransomware or loss of data, and actually ensuring that that people's software in fact complies with privacy laws is definitely an area that I think is going to be of increasing focus.
They're both excellent points. Two quick things that I wanted to add was we certainly see with our clients now there is a real focus on the porous nature of technology products and services at the moment. The fact you have so many different interconnected parties working together. Some may have more of a superintendent role, some may be the base provider, some may build some tech around the side. But because we have all of these different pieces of technology and APIs talking together, you have some real challenges around assessing, well, if something goes wrong, whose responsibility was it? And we're also seeing some interesting trends in terms of some of the way in which supply chain is changing. So again, smart cities, the real focus around the industrial Internet of Things, all of those types of elements we think for clients that play in that space and work in that space, they're going to have a lot of regulatory challenges. The next one that I wanted to very quickly touch on was on the exposure side. As Petra's alluded to now, privacy does create a slightly different dynamic for tech product and tech service firms in that their underlying clients often wear many of the key liabilities with the regulator and incur many of the key expenses straight away. So that makes them think about their technology product and service providers very differently. So we see a lot more focus now certainly on indemnity clauses. We see a lot more focus now certainly on trying to have an understanding of what the losses might be and where a contractual failure might occur. Loss is always a good segue, I think, to explore a few things around insurance and also cyber risk more generally. And Petra, one of the ones that I always find quite interesting is that when we speak about the technology product and service firms, there's an assumption that these are the best of breed, these are the strongest, the most sophisticated, the most capable organisations of managing these risks. Despite this, we see a huge stream of reports in the media of technology service providers being breached and causing a number of these major cyber incidents. Why do you think that's the case? And do you think it is true that a number of these organisations are cyber mature or maybe not as mature as we hope? Oh, Petra, you're on mute.
Thank you. It's a complex question. Why are they being targeted? I think actually one of the points that Nitin made earlier was one of the key ones, which is that technology companies tend to be sort of aggregators of data, and they are a great target for bad actors, because they can attack a lot of data in a much more straightforward way. I think the other thing that I tend to see is that technology companies move very fast. They also tend to be they have a risk, an appetite to risk, which is they're more comfortable with risk than a lot of companies. And so they're moving quite fast, and they're potentially doing stuff which is quite risky. And even if they are focusing on cybersecurity to a very high extent, nevertheless, that environment does make it easier for people to find ways in. So I think that there's that aspect. There's the fact that we're certainly seeing a move towards targeted attacks, and again, that a lot of these companies are very tempting targets, and so that's definitely going there. And I think the final point that I'd make in relation to this is I think the tech companies are more vulnerable to insider threats. You know, inevitably, their staff are tech savvy. They're capable of committing attacks, and there tends to be quite fast turnover of staff in tech companies. And so I think you do have all the ingredients there for there to be insider attacks by disgruntled employees. So those are the key things from my perspective.
I agree with all of that. I think the parts that I'd add are, when we think about cyber risk now, you'll often hear the term supply chain breaches. And to echo what Petra's been talking about, if you can get an organisation that's a bit of a honeypot that either has very high privileges in a bunch of their client environments or has a piece of product that you can then compromise, for a malicious actor, they get a very high level of bang for their buck. This isn't a new trend. We've seen it since about 2014, 2015 with things like the Cloudhopper attacks, but the prevalence is certainly much higher. The other thing I'd say with the technology product and service providers as well is the nature of the type of data that they hold is often very high valuable assets. They'll normally have a high concentration of financial, health, sensitive personal, sensitive corporate. So it does mean that they're very, very prone for social engineering attacks. It means they're actually worth the effort from malicious actors. So even if they are mature, even if they are quite risk advanced, they are just such a tempting and tasty target, they will likely continue to be a large part of the significant breaches that we see. We've talked a bit about the environment, and we've tried to highlight that it's very, very dynamic. And so the next piece we want to add is the way in which organisations are looking at IT projects and the way in which they're being procured and managed. So I want to ask the panel, what are some of the key issues that they see coming up when their clients either look to retain technology product or service providers, or when they act for those providers? I think this is another good one to throw to you first, Angela.
Thanks, Ben. So I think sort of going back to the first question, because what we're talking about is such a really broad range of services and products, it's hard to talk about a general trend that impacts really everything, because, for example, procuring your new telephony system or core IT services will be very different, or will raise very different issues to the services or issues that might arise for different types of technology products and services, like the ad tech products that I mentioned earlier. And also, of course, the issues that concern procurers of those products and services differ depending on whether we're talking about someone in the private sector or the public sector acquiring those products or services. So in light of the fact that I could really have talked about anything, I thought one topic I would pick would be data sovereignty. So in sort of mid last year, the federal government advised that it was undertaking a review of sovereignty requirements in relation to government data sets, and looking at the question of whether certain more sensitive government data sets should be hosted on data servers located within Australia. So that sort of bubbled away for a little bit, but fairly recently the digital transformation strategy has been modified to incorporate a hosting certification framework. So what that framework deals with is hosting services, including space in data center facilities, and also the supply of telecommunications infrastructure. So that framework has a stated aim of supporting the secure management of government systems and data, really by focusing on security provisions for hosting providers. So looking at protecting privacy and also improving resilience. So in terms of data sovereignty, they're really talking about stringent ownership and control conditions. So technically, it's not intended to exclude foreign ownership of data centres in Australia that are used by the Australian government. And that's certainly not a requirement to get the highest level of certification, but you do need to give a level of control, in effect, to government. So the interesting thing about this is that it is intended in due course as it's rolled out to apply to both direct and indirect providers of hosting and related data center services to government agencies. So the sort of indirect providers that will be included will be cloud service providers, quite obviously. So it will be interesting to see what happens as the certification framework is rolled out, which is intended to occur over the next year, and whether that impacts the type or the service providers that government uses for particular services. And although this really is an issue that has been highlighted by government, it's also increasingly common, I think, particularly for larger clients, to be concerned about data sovereignty as well. So it's all very nice to talk about, you know, your data's in the cloud, but people actually want to know the location, know what laws their data might be subject to, and that also links into some comments that Petra made earlier and some comments I'll make later around privacy. So you want to know where your data is to make sure you can comply with Privacy Act requirements as well.
Thank you very much, Angela. Nitesh, do you have anything you want to add?
Yeah, look, I've looked at it from a slightly different perspective from Angela, but it ties in with a lot of what Angela has said, especially around the focus on security, privacy, and data handling. But effectively what I've done is I've looked at it from I see it as a two-speed approach almost. So you've got your approach that's been taken by the more sophisticated clients, and then you've got a separate approach for some of the newer players who are less sophisticated. So from the clients who are more sophisticated, it ties in a lot with what Angela has said. There are more steps being put into the process. There's more rigor around an investigation into the whole project itself, that if it's a project or if it's a product or if it's a service, they want to get into the weeds a bit more around where, as Angela said, where any data is going to be held, where any programming is going to be done, on what devices programming is going to be done, how access is going to be granted to a developer to undertake the development, and those kinds of things. So just to get a really granular understanding of what it is and what it means to be, you know, in terms of your security obligations and your privacy obligations and your data handling obligations, where things are actually happening, how they're happening, and how the data flows are going around. There's the imposition of third-party obligations that we touched upon previously, and I think we'll touch again on a little bit later, around and at the moment it's somewhat initially clumsy, I think, speaking honestly, that it's just a blanket imposition rather than any kind of tailored approach, but through a proper process that's adjusted and incorporated appropriately. But that again is causing some delays in the procurement process. And then something that's already been raised, but I think it's very relevant here, there's a real pushback on liability limitations. And tying in with that is often a clarification of assumptions that's giving rise to the actual project. So there's a real focus on some of the touch points to try and smooth out the process, but it's also meaning that the whole procurement process is taking a bit longer. That's to be contrasted, I think, for the newer players and who are somewhat less sophisticated, who can be less sophisticated, I should say. They tend to be generally price-driven and then goal-driven, without always knowing the process to get there. So they've got this idea in mind, and they've got the provider who they've gone to, and then because it's so price-driven, and there's a real desire to get the product, to get the project on the tech provider side, there can be shortcuts made. There's only limited scope assessment undertaken. And there's a whole bunch of ambiguities. There isn't that proper understanding or setting out of what the obligations of not only the provider but the actual client is in the whole process, and that's all to seal deal. So that's almost the opposite of what we're seeing from the sophisticated client side, and that's something that yeah, look, if it comes to us, that's something that you're trying to address as soon as you can, but often when you see it from the claims perspective or the disputes perspective, that's what you see as being the start of an unfortunate set of events.
Thank you very much, Nitesh. One point you made, and I don't know if you or anyone else on the panel wants to take it, but you did talk about data flows. I know there's a huge amount of interest for organisations trying to understand their own data flows. Do you think many of them actually do, or is this something where we might see some future disputes and tension?
Yeah, look, I can say that with, I don't want to say too much, but I can say that there is perhaps not the understanding of the data flows, not as great an understanding of the data flows as some organisations might first think. I think a lot of businesses believe they've undertaken the exercise to understand where the data flows have gone, but because of the inherent fluidity of this industry and how quickly it evolves, what you once thought was the case with your data flows is now changing. You change your environment, and that means your data flows have changed. Depending on the client, your data flows can change. Depending on your client requirements, your data flows can change. So I think the short answer is not really.
And this is probably a discussion for another point, but it is always amusing when a client talks to you about their data flows and they haven't thought about access controls or access management. So I'm very aligned with you, Nitesh. I think that's a topic that we're going to see a lot of tension with over the next couple of years. Moving on slightly and thinking specifically of cybersecurity requirements that we're expecting from technology product and service providers. Angela, did you want to make any comments on what you're seeing with your clients or more generally in the market and how that expectation of securing and managing privacy is being dealt with?
Yeah, sure. In relation to this, I wanted to talk a little bit about managing privacy exposures and dealing with data breaches, because as I'm sure everyone in the audience knows, we're in the middle, so to speak, of quite a slow process for amending or reforming the Privacy Act. And one of the things that's been raised in relation to that Privacy Act review is how the mandatory notification of data breach regime provisions work. So the way our Privacy Act works is basically anyone who holds personal information is regulated, provided you meet the relevant thresholds. And the data breach notification regime imposes on those regulated entities the same obligation. So in respect of one particular data breach, you might actually have multiple entities who need to comply with the notification regime. So if you collect customer data and you store it in the cloud, if something goes wrong and there's a data breach, you and your cloud services provider may both have obligations to notify your customers. And you know, when the regime came in, everyone had a nice standard clause that, you know, you talk together and resolve the issues. But it does get quite complex, and particularly because if no one complies then with the regime, then everyone is liable. And that's resulted in things like, for particular data breaches, the Office of the Australian Information Commissioner getting up to 60 notifications from different entities in relation to that breach. And I would think if there's anything ripe for reform, that would be it, to allow technology products and service providers to work better with their customers in relation to that notification regime. And I know a lot of people say that the answer to this is adopting the GDPR model, which distinguishes between people who control the data, personal information, so data controllers, and data processors, so people like cloud providers or other service providers who just process the data on behalf of the controller. And while I'm not entirely in favour of that, but I think it would be really helpful if we did introduce some sort of regime like that, where the entity with the closest contact with the end customer has responsibilities. Otherwise, we're just going to continue to see increasingly complicated regimes for dealing with notification of data breaches and the other obligations that come with that regime in the Privacy Act.
Nitesh, did you want to add anything there?
Yeah, thanks, Ben. I think the area I wanted to focus, because there's a number, it's what is being demanded by a particular client, I think, is dependent on the client and what their obligations are. And I just wanted to focus in particular with, and I've mentioned it a few times, but I think it's probably time to go into a little more detail on APRA-regulated entities, just because it is a fairly large sector, and it does impact many tech providers and many service providers generally. And that's that CPS 234 obligation that they have. And in it, without going into chapter and verse on it, it effectively tries to impose a top-down approach to not just privacy, but data and system security. It looks to impose that on the APRA-regulated entity itself. But one of the key elements of that is that it then tries to impose a requirement on the APRA-regulated entity to know what its third-party providers are doing, and not just its third-party providers, but anyone else that the third-party provider uses as well. And it basically puts the responsibility on the APRA-regulated entity to make sure that effectively what's in CPS 234 is largely imposed on their supply chain. And so the impact of that has been all those obligations have been pushed down the supply chain. And you've seen some, and we've seen some pretty strong language around what that therefore means for the regulated entity. They're effectively trying to say, you will ensure you do X, Y, and Z. And the reality is you can take reasonable steps to prevent or to mitigate risks, but you can't ensure certain risks will not occur. So it's that kind of language that we're seeing, and that kind of imposition, the criticality and sensitivity of data, making sure that the supply chain is undertaking those kinds of requirements are being requested. A real deep dive into what the supply chain is doing in that space. And the reality has been that many businesses at the moment are just not equipped to be able to undertake that exercise, or haven't undertaken that exercise at this stage, which is causing a bit of a bottleneck. And for most of our businesses, we've been able to, again, manage that requirement and say we are taking X, Y, Z steps to assist with that obligation. But for other businesses, I'm curious if they're just saying, yes, we will, without really thinking about what the consequences of that is. The other thing we're seeing that coincides with these greater obligations is a pushback on the limitations of liability, which again ties in a bit with these greater obligations and the greater exposures that are now being faced as a result of breaches of cybersecurity or system security. And so where once upon a time you'd have those kinds of clauses of, well, we limit our liability to 1.5 times the amount you've paid us, those kinds of things are really being contested at the moment. To the extent that they do apply, there's questions around the extent to which they apply generally, but to the extent that they're already in there, they're being scrutinised and pushed back on. Insurance requirements around cybersecurity, cyber policies. So cyber insurance requirements are being now imposed on major projects in particular, and ongoing service offerings, which is something that's relatively new to the obligations that are being imposed compared to previously. And then look, greater focus on reviewing and auditing the measures that are being put in place.
Yeah, and I certainly agree with all those points. The piece I'll add is more what we've seen on the macro side with a number of our clients, which was there was certainly a realisation that there needed to be some type of minimum cybersecurity or information security standards for a lot of the vendors, and this tended to be pushed out personally from the large financial institutions, some of the large listed clients. We saw a lot of those clauses getting through to the keeper, in some cases quite surprisingly. Now, though, there's a lot more pushback, and we see a lot of variance and a lot of tension around the contractual controls that try to sit here. So if you want to take the most benign, you'll see some that will just tie to compliance with privacy law or some type of industry standard. They're quite ineffective, though, because you can't really hang any damage or anything of substance off the bone. We are, similar to what Natesh has mentioned, seeing a focus on insurance requirements. And insurance is useful if it's cyber, because that means the organisation will have some support when they have the event. But you've also particularly got to ask about the professional indemnity and the IT liability where suppliers and the tech products and service companies have. We're also seeing a lot of focus around how reporting should happen when there is a cyber incident. So, for example, what needs to be said, what's the time frame, ongoing cooperation, ongoing communication. There's definitely a lot of tightening around the liability provisions and how breaches of confidence or privacy can trigger that. There's a lot of focus on audit provisions. To be honest, most of the ones that we see aren't very effective, and I suspect there'll be continual pushback here. And the last one that I think is really interesting is there are now vendors and third parties that specifically play in this space to help you analyse your IT provider's cybersecurity or maturity, and to try and give these automated assessment reports. They're becoming quite commonplace, and we suspect we'll see more and more of those in terms of how we think about that due diligence. That was a pretty long question, but I think the next one we might get into is a little bit more of a confined issue that we see a lot happening in the technology space. And I want to ask Natasha, you firstly, about the problem with scope creep. And when we're procuring specifically technology service contracts, what's happening here, how is it leading to disputes, and what types of issues or results are we tending to see?
Yeah, thanks, Ben. I'm not sure if it's going to be too much of a shorter question, unfortunately, but I'll try to keep it fairly succinct. Look, it's an increasingly common cause of dispute that we're seeing, and to summarise it, I think it arises generally from a combination of two key issues. It's an ambiguity in the scope initially, and then a failing to manage client expectations through the process. I'll probably expand on that ambiguity of scope initially. There can be issues around the scope becoming ambiguous through the process and that not being properly managed as well. So I think the ambiguity in the scope initially is fairly self-explanatory, but effectively it's where you've got an idea or a concept that hasn't been properly broken down into its constituent parts and properly and the various requirements of the client are not properly identified. And as many people in the audience will know, one change by a client can mean something that may seem fairly straightforward from the client's perspective, can actually have a significant development cost and blow out the timing of a project fairly significantly. Now, if that happens, it's really important that that is immediately addressed and immediately brought to the client's attention. And following on from this issue of scope creep, following on from this issue of the ambiguity, where that's then not properly managed, effectively what's happened is you start creating a mismatch of expectations, and you've got the developer, or you've got the provider who's embarking on a course on the basis that this is now something that's beyond the original scope and it's going to cost extra. Whereas you've got the client who's thinking, well, this is part and parcel of the scope. You've started creating this issue of scope creep. That's one way of it occurring. The other way of it occurring is that there's a known addition to the scope, but the provider doesn't properly identify that it is a variation, doesn't properly communicate that to the client, proceeds to start embarking on the additional work required without properly specifying that it's a variation and without properly pricing and alerting the client to what the additional costs and time might be around that. So again, that starts creating a mismatch of expectations, and the client starts proceeding on the basis that that's just being included or thrown in, and the provider is proceeding on a different basis. And so that's where that management expectations comes in, and it can also sometimes be the result of a lack of clarity around how to deal with variations in the actual agreement itself. So it often helps where there's a clear process in how to identify and deal with variations within the documentation. Sometimes it's not followed, but if it's there, it at least gives that roadmap of how these things should be dealt with. If that's not there, that can create all sorts of issues around, again, how do you now deal with this variation in the project? And just to, again, to raise the issue of sometimes what might be seen as a fairly clear scope initially becomes somewhat more ambiguous as you go through the project, because again, the nature of these projects are generally fluid, and you want to do the best. Both sides have the intention of trying to make the most of this project, and so additional things can be thrown in, and if that's not properly managed, scope creep will come into that. So look, all of that results in mismatch of expectations. You'll get to a point in a project where suddenly where you were meant to be 40, 50, 60% into into the development of something or the like. You're nowhere near it, and you've eaten up most of the money, and then you tell the client, well, great, we're going to need more money and more time, and the client will turn around and go, what do you mean? And more often than not, you'll try and resolve it, but that can lead to some fairly difficult discussions and some, unfortunately, dispute resolution or litigation. The other way it can occur is if you're a general services provider and you've got a bunch of services. So if you're a managed service provider and you provide your ordinary managed services to the extent that has a meaning, and that doesn't include cybersecurity, for example, you then assist your client with a cybersecurity incident without clarifying that that's not part of the ordinary scope of what you do. Then there can be a real confusion, or there can be a lack of understanding or a mismatch again of what it is that is within the scope and what it is that is not within the scope. So again, it's coming back to that same issue. And then look, I'll leave some content for some of the other panelists, but look, effectively it'll lead to a number of different allegations and claims for loss and the like.
Petra, I'm sure you've seen a few of your own scope creep related issues. Is there anything you want to highlight?
Yeah, sure. I've certainly seen plenty of them. As Nitesh says, they mainly arise out of that mismatch of expectations, between the contracting parties. I would say most of the claims that I see arise out of the gaps. They tend to be stuff that people haven't done rather than stuff that people have done. Scope creep is absolutely one of those. One party assumes that something's included, then halfway through everybody realises it isn't. You've then got to expand the contract to include it. So I'd certainly absolutely underline all of those points. But what I would say is that I think scope creep is wider than just software development. In that I actually see it more widely in contracts, and specifically in that situation where the contracting party is actually trying to be helpful, and we see this a lot in the tech space. And what I'm thinking of there is, where you're supplying a service and you try and be helpful and you go beyond what you've contracted to do, and you then unwittingly acquire a liability. I'm dealing with a claim at the moment involving a fairly large cyber breach, where there was a company providing an email security service. All lovely. We don't yet know whether the breach has arisen out of something coming through that email security service, but we're probably quite safe on that. The difficulty is that the company has provided additional free advice on additional steps that that their customer could and should have taken to secure their system, which they didn't take. And their perspective is, well, didn't we do a wonderful job? My perspective is, yeah, you've probably opened yourself up to a liability there that wasn't in the original contract. So I think that it's worth bearing in mind that scope creep can go a lot wider than just as traditional software development. The other point that I would make, just from a practical issue in dealing with these kinds of claims, is that inevitably these claims arise whilst the contract is ongoing, and so you are trying to keep the wheels back. You're trying to keep the wheels on the wagon and keep things rolling, without the contract completely falling over, because everybody wants to get to the end of the project. And that's certainly one of the biggest problems that I see in dealing with these types of claims, because you're trying to weigh up the legal liabilities with all of the commercial realities of parties that are wanting to continue to contract with each other. And so that's really quite something of a tension when you're dealing with these claims. It's well worth thinking about. Certainly when drawing up these contracts, just thinking about that resolution process. A live dispute at the end of it. So, yeah.
Thank you very much, Petra. Nick, I guess when the rubber hits the road, that's when we tend to see these types of issues. Any things you'd like to share in terms of scope creep or other problems?
Yeah, look, I think both Nitesh and Petra have made some pretty important points. The thing I would add, at least from my observations, when these matters have gone bad as they can, is that it's important to understand that customers can often just lack the capacity to precisely state what they want from a technology service contract, and there can be different reasons for that. Maybe the person negotiating on behalf of the customer is just not sufficiently technically adept to be able to talk to the contractor and tell them what they want, or it might be that they are sufficiently technically adept but they don't have the skills or the support to understand the problem that they're trying to solve. Those are things that I've seen in litigation in this area. And it might just be, following on from that, that the customer just hasn't done the work yet to understand its own needs before it enters into negotiations with the technology provider. I see a lot of similarities between litigants dealing with lawyers and customers dealing with software providers, technology providers, because in both cases there's a big imbalance in understanding between what the customer understands can be achieved and how it might be achieved, and what the service provider understands. And I think it's important from the projects that I've been exposed to, and you've got to remember, Ben, people like me and you and a lot of other people on the panel tend to only see these projects when they go bad rather than seeing the good projects. So you've got to remember that's the perspective that at least a few of us are talking from. But I think what some of those things lead to is that sometimes, and I think someone's already had a related point to make about this, once the project progresses, and particularly when it gets to sort of user testing, the buyer starts to realise that the software won't do everything that had been hoped, and it's really difficult to renegotiate things at that point effectively. And as Petra was saying, keep the wheels turning. And I know we're going to talk in more detail in a moment about the sorts of litigation that can result, but I guess the broad legal issue, if it's a legal issue, is that tends to result in these circumstances is that if the project has been imperfectly understood and hasn't been properly documented both at a technical level and at a legal level, that's where things start to go pear-shaped, for want of a more technical term.
All brilliant points, and completely agree. The two pieces that I'll add to this is there is also a commercial tension that I think leads to a number of these problems. Is for many of these technology service and product providers, it's a sales-led engagement with a lot of the clients. They have significant people in their sales team that are commission-based. What they will do and what they will say to get the commission may actually result in an expectation gap in terms of what the people on the ground that are going to be delivering and doing the project. And the second thing that I think is an excellent point you raised, Nick, is this is one of the areas where documenting the contract can get very, very hard. It's not something where a lay lawyer can look at this and just write the contract. They need to understand exactly what's happening on the technology side. They need to speak to the people that are going to be intricately involved, and there needs to be a lot of decoding and sitting at that parallel between the service and between the underlying tech. So I suspect we'll see many more of these as we go through in the next few years. Playing on with what we've talked about, I do want to look specifically at the legal recourses and the types of issues that tend to get litigated when we have disputes with tech product and service providers. You've already given us one example, Petra. Why don't we see if you've got any more to scare us with?
Thanks, Benjamin. When I was looking at this question, I thought rather than just sort of give you my random thoughts, I thought I'd actually look at some stats. And so I had a look at the claims that we're seeing that we've had notified to us over the last couple of years to see exactly what sort of claims we're getting and what's being pursued. And the answer was, I was relatively surprised actually. 25% of the claims were cyber attacks on tech companies' clients. So I was quite surprised how high that was, by, definitely the biggest chunk of claims, followed by software development disputes, followed by service failures, followed by intellectual property disputes, interestingly. So those are the top contenders. Within that, what I would say is, what I see with tech claims is that they tend to be low frequency and high value. And the net result is that what tends to happen with the relatively small number of low value claims, they are almost always resolved through the fee dispute mechanism, and get resolved within that context. The higher value claims do tend to be litigated. There is almost always an arbitration or mediation clause in the contract, but I find that almost nothing gets resolved at arbitration. Everything ends up in litigation and gets settled at mediation as a rule. So that's certainly what I tend to see, with a fairly broad brush approach to it.
Anything that you want to add there, Nick?
Sorry, I forgot to hit the unmute button. Look, I don't have stats at my fingertips the way Petra does, but I would guess the big issues in terms of the obvious issues in terms of litigation are breach of contract claims and damages for misleading or deceptive conduct. But I think one issue that ought to be added to that touches on something Petra said earlier about where they take it on themselves to provide some extra services. That opens up an extra area of negligence where you create an expectation for someone, even if there isn't a contractual responsibility, you can still be liable at that level as well. So it's fairly important to, I guess, stick to what you've undertaken to do and not get outside that, because at least not without going back and documenting that properly as well. The documentation is very important, and I see one of the questions that's come up in the field from one of the audience relates to whether one of the problems is that contracts are not faithfully mapped to the customer's business case, and that can often be the fault of lawyers. Yes, it can. It can sometimes be the fault of the lawyers, but it's sort of a species of the problem that I was talking about earlier, that if you don't have everyone seek and succeed in understanding everyone else's expectation in the course of negotiating these things, that's where people like me start to make money. So it's all very well to say, well, that was within the province of one of the parties to the negotiation, and so that's where we ought to be looking for blame, if you like. But it makes sense for everyone in that negotiating room, and I suspect this is more in Angela's field than mine, but it makes sense for everyone in that negotiating room to be absolutely across the perspectives of the other people in the negotiating room, because that is one of the best ways to protect. I think the topic was focused largely, Ben, on the sorts of claims that arise in these circumstances. I had a couple of thoughts about that. One is that if the technology firm is involved at the scoping stage, then, and this comes back to the negligence point to some extent, the questions arise as to whether it has a duty to ensure that it understands the customer's needs in the first place. So it's not only about what you contract to do in terms of building the solution, but whether you've effectively contracted to give them advice on what the solution should be. That is something that comes up from time to time. And following on from that, it might be alleged down the track, if there is litigation or arbitration, that there's been some sort of misleading or deceptive conduct in terms of representing what would be provided. So the customer might say, well, I was under the impression that you were going to give me this, but you've only given me this portion of it. And I guess the other thing, and it's really subordinate to that, is that there are likely to be arguments that the software has been said to be fit for purpose when it isn't. Those are the things that that are most likely to come up. There's one other sort of issue out in a different strand that I'd point to, and this is probably mostly related to smaller ventures, and it's the failure, particularly when two people or two firms are coming together, to properly address IP ownership when they're forming, particularly if each of them or one of them is bringing stuff to the project in the first place. And so that's another fertile area for litigation, I think, as well.
Thank you, Nick. I think I'll just make one brief comment on the point that was raised about mapping the service to the business needs and the requirements of clients. Clearly a common issue, and almost all of the claims involve that in some aspect. One of the bits that I think we don't quite understand and why that comes up is because there are some illusionary smoke and mirrors that happens in the tech product and service industry. Someone will come to you with a software as a service, a SaaS solution, and will give you the impression that this is customized, built from the ground up for you. That's never the case. It's one bit of software. It goes to all the clients, and there's just a bit of tinkering done for you. So in some cases, we can't really always map these to individual client requirements, but the providers still pretend, and that is always going to be a really lot of tension and a really live field for future disputes. We've slightly covered this already, but I do think that it is worth having a real lens on where and when these claims succeed and what are the types of obligations that technology service providers fall down on. Nitesh, was there anything that you wanted to add there?
Yeah, look, thanks, Ben. I think I just wanted to echo your comments and Nick's comments on that question from the audience around the deliverables piece. It's something that I deal with fairly regularly, and the reality is that we as lawyers will give it a go, and we can look at it from a third-party perspective, looking inwards at that procurement stage and at that agreement stage to say, look, this doesn't make sense, this doesn't make sense. But it's really the two parties who have the best idea of what they actually agree to, and to the extent we can identify that this doesn't make sense to us, it's really more just, okay, that needs to be clarified with that needs to be, you need to make sure that both sides understand each other on that point. Beyond that, it's really, again, a matter that's in the remit of the two parties who are looking to come into the agreement rather than the lawyers per se. But then onto the actual question at hand here. In terms of are claimants successful or unsuccessful, I think it really depends on how you define success. Do they get everything they want? Most of the time, no, but they generally get some level of success to a degree. And again, that's looking at it from the technology provider's perspective, rather than the client's perspective who will bring the claim. They may see half of what they see to be their loss as not successful, but the long and the short of it is, from the provider's perspective, they will need to give something up more often than not to the claimant. And part of that is because of the inherent vagaries and fluidity of most of this industry. Things do change, things do evolve, and that can lead to mismatches, as we've mentioned, and these kinds of claims. And so it can be difficult to say you are always completely in the right in those kinds of circumstances. In terms of the failures of legal obligations, I think it kind of crosses over a bit with what Nick said. It's breaches of contract, various clauses of breaches of contract, negligence, misleading or deceptive conduct, fitness for purpose, and the other one, depending on the size of the product and depending on the contractual terms, breaches of warranties and guarantee. Where that's for smaller products, there's the AUSCL, so the Australian Consumer Law provisions in particular, that can be relevant, and they are the amount limit on that is being increased, so that's something to keep an eye out for various providers. And then in terms of why do these disputes arise, I think it kind of covers a little bit what we've done before, but providers tend to fall down on confirming or clarifying the scope, setting out or clarifying the reasonableness of assumptions, properly communicating progress and managing costs, how to deal with variations, the processes for project progression or completion, if there's an early termination, or if there's otherwise, as Nick also mentioned, the issue of how you deal with IP and the mixing of IP and the creation of IP, especially when there's a dispute around payment. When is it that the IP is said to have transferred over to the client?
Over to you, Nick. Any other insights you've got on when claimants tend to succeed, and also any other dispute stories that you'd like to share?
I thought what I might do is just talk about, sort of from my experience, where I've seen sort of real deficits in the way technology providers sort of do business, which has led to problems in litigation. And I guess I don't have stats, and you can't really look at the cases and see how many people succeed on a particular issue and how many people don't. So it's not, you can't really address it from that point of view, but you can talk about things which come up again and again. And one of the things, it mightn't be the biggest issue, but it's the one that surprises me the most, I guess, in the technology space, is how often tech companies of different sizes fall down on record keeping and what we once might have called a paper trail. It's probably not the appropriate term in this particular setting, but you know what I mean, just a documentation of what's happened along the way. So there isn't sometimes what you'd hope for in terms of recording their interactions with customers and recording when orders are made and recording when variations are ordered if it's a contract for building a solution. And it's surprising to me because of, you know, who the players are, but my own gut feeling about it is that particularly in smaller operations, you've got a bunch of people who are focused on their core task, and admin just isn't paid as much attention. It matters because, at least from my point of view, in litigation, particularly in commercial litigation, most contests about what happened are resolved by reference to documents, and the documents that were created at the time that things were happening. So because most judges regard that as a much more reliable way to work out the truth than looking at someone in a witness box and telling whether they're lying or not. And that means that proper documentation is really critical. Organising it so that you can find it easily if the need arises, but making sure you do it as well. That is a hit. Sorry, I've just lost the light. It looks like a horror movie. But the advantage it provides you in the litigation, if it comes to litigation, and even when you're at alternative dispute resolution stages, is pretty important. So that's my insight into that area. There you go.
Thank you very much, Nick. And given your flickering lights of distress, we might try and push through the last three questions quickly, as I want to make sure we've got some time for the audience Q&A. Angela, I will quickly throw over to you, though, whether there are any other insights that you want to share in terms of the litigation and dispute issues that you've seen.
I think we've largely covered the field in terms of current litigation topics. So I just thought I'd look a little bit at the future as to where things might go. And again, refer back to the Privacy Act, but also refer to actions that the ACCC have taken that are likely to have impact for technology providers broadly. So, under the Privacy Act, individuals can't actually take action in the event of a breach of privacy that relates to them. So they can't commence court proceedings. And the Privacy Act review is actively considering whether such a right should be given. And if it is, one can expect not just in relation to data breaches, but other privacy-related issues relating to how data is stored and the like are likely to come up under a reformed Privacy Act regime and create litigation and also potentially class actions. But and I think it was Nitesh that mentioned misleading and deceptive conduct claims. So that the ACCC has, in a sense, become a bit of a de facto data champion, so to speak, in that it's taken, it's completed 2 cases where it's been successful, so Health Engine and also a case against Google in relation to location data, where it's argued that the data practices of each of Health Engine and Google were misleading and has been successful. And it has another case against Google and another one against Facebook. And you could see that sort of misleading and deceptive conduct type claim morphing into broader claims, potentially not just involving the direct provider of the service to consumers, but the cloud service provider that the relevant entity uses or other IT service providers being caught up in that sort of action. And I do think it's something that businesses are increasingly nervous about. Will there be the potential for these sort of claims, even if there hasn't been a data breach?
Perfect. Thank you very much, Angela. For our last session, before we get to the concluding thoughts, I did want to go back to the insurance lens, and particularly now we're seeing a lot of issues around insurance and insurers trying to understand the maturity of clients and particularly technology organisations. When we look at these technology service companies, I'll throw this to you first, Petra. Are there any red flags or issues that insurers are becoming worried about, or key trends that are emerging?
Sure. I mean, certainly the continuing evolution of the tech sector does make it quite difficult to accurately underwrite. Certainly, my preference has always been to actually go and visit potential insureds. That's the only sensible way that you get an understanding of what organisations are like. But if it comes down to one simple thing, it's governance. Organisations can have, they can have wonderful manuals. They can tell you all about their processes, but it's the sense you get of the governance and the attitude at the top that makes 100% difference. And so, certainly, if you're seeing an organisation where the board are taking insurance and risk issues seriously, that's the key. If you've got independent board members with expertise, and in particular what we're seeing now, particularly with the smaller startups, is a move towards virtual C-suites where you get specialist external people in to fill some of those C-suite roles. Those are the kinds of things that make the difference. So, and they're things that you can look at despite the pace of change, because those things don't change. But basically, leading from the top is where it's at.
I think your comment of change there is very important, and certainly what we see now is there are industries that have almost become dirty words. So if you are a tech company that's a payment processor, there will be lots of questions, and there will be lots of questions asked of you. We're certainly seeing some tension, some concern around medtech. We've got a few clients that we've been speaking to where they play predominantly in the low-code and no-code environment. And when underwriters finally work out what they're actually doing, in a lot of cases, their jaws drop. So what I would really be focusing on here is where you are a tech company that's certainly sitting at the edge of where either the regulatory space is or where space is, or if you're doing something that relates to very sensitive data or things that will have a privacy or financial loss from a breach, there are certainly red flags, and there's certainly issues that there will be a lot of attention spent on. Did you want to add anything there, Nitesh?
Yeah, look, I mean, I don't see it from the insurer side, of course, but we do speak to insurers and then the insureds themselves. And I think a couple of touch points was the clientele of the particular provider can make a difference as well. Simply because, again, if you're dealing with a less sophisticated clientele, that can lead to greater exposure as compared to if you're dealing with more sophisticated clients. And I suppose the other trend that we hear is that there's a lot more questions, as you mentioned, Ben, and also some real focus on recommended steps to improve your cybersecurity. So, like the Essential 8, for example, is one that's coming up a fair bit among a few others.
Staying on with that and the concept of insurance, from your perspective, Nitesh, are there any specific insurance covers or insurance program issues that we tend to find with technology product and service providers? And also, what are the most important insurance covers that they tend to be relying on?
Yeah, look, I mean, I'll just touch upon this very, very quickly. Just conscious of the time, but look, the professional services definitions is one of the big ones. That making sure you properly identify what that business is, and making sure that the business that you actually conduct is captured within that concept. Cyber cover is a big one, and again, making sure that the cyber cover and the limits and sublimits and any kind of exclusions and at the moment endorsements are properly tailored for that particular business. Again, the real property damage is a real kind of question mark for not everyone, but for a number of key businesses. For example, those who have technology that controls manufacturing processes or the like in particular. As an example, so there tends to be a gap in cover at the moment around that. Unpaid invoices and refund of fees is another one that tends to a lot of these two particularly tend to be either extensions to cover or the like, rather than being just embedded or included as part of the general cover for some policies. Other policies do it differently, but that's one to keep an eye on, and then the sublimits around that, and the triggers for those two concepts are also important. And then contractually assumed loss, which is a bit of a minefield of a space, but again, just being aware of how that cover is provided or is excluded is important to understand from a technology provider's perspective, just because again it flows from a number of issues, including something that I think it was Petra mentioned around the mismatch between we'll call them the big boys and what they want in terms of almost complete exclusion of liability, and what they try to impose down on the smaller providers, effectively meaning that they assume a lot more of the risk.
I agree with everything you said, Nitesh. The couple of points I'll just echo there are, we do see attention with a number of the tech providers by not mapping what the insurance is doing to what they actually need. People need to understand that many of the insurance products you get off the shelf, they're specifically general. And while if I've got an investment manager's piece of insurance, I know generally what investment managers will do, technology product and service providers can do a huge range of things. And unless you spend the time and the effort to match that to what the business is doing and the business needs, you will see a number of problems for clients where when they have the major issue, the insurance just isn't there in the way that they assumed or in the way that they would have liked. So that's about partnering with the right people, both in terms of the insurer and the broker space. A couple of key things that we're also seeing at the moment is the way in which tech providers are playing, particularly in the Internet of Things area. That's creating the need for some custom covers. Particularly, we're seeing some things around OT-related support services. That might be in terms of maintenance, monitoring, some of the optimization. All of those types of things should be very, very carefully considered, because typical out-of-the-box insurance doesn't really cover that properly. The other two things that I'll say is the business interruption triggers become very, very important, specifically on the cyber side, because when these organisations have a cyber incident, they can have a very immediate and very substantive impact to their operations. Last thing that I'll just say too is I think the contractual liability is very important to consider and think about because of the diverse range of contractual responsibilities that they have, but also because you will find that in a number of situations, particularly when you're dealing with larger organisations and larger clients, the contract is what they will keep coming back to. So if you can get certain things around hold harmless and other things included in the policy, that's a very big benefit. We're coming very close to the end of the session now, and what I'm going to do is I'm actually going to combine the last two questions we had, which were about recent or impending legal and regulatory changes, and also key thoughts that the panelists wanted to share with the audience. So I'm going to throw that question firstly to Petra. So please regale us with your words of wisdom.
Okay. Regulatory changes. I look at this from the New Zealand perspective. So for what it's worth, the big change here obviously was the Privacy Act, which came in December last year. So we're still trying to work our way through that. And you know, I think we're in that over notification stage at the moment. You know, where everybody's so nervous that they're just notifying things to the Privacy Commissioner. So we'll see that settle down at some point. The other area that I see development in, it's also in the cyber arena. And it's not so much a regulatory thing, but I'm seeing a lot of work going on around cyber accumulation management. You know, certainly Lloyd's of London and some of the reinsurers are doing a lot of work around accumulation management to, you know, to ensure they're not overexposed in the cyberspace. And I think we're going to see that coming into play a lot in the future. And associated with that, I think the American government's approach to sanctions and how that applies to paying ransom payments, I think is going to ripple around the world. And I think we're going to see that start having an impact in the future on how we deal with ransom claims. So those are probably the key things that I see coming up.
Angela, over to you.
Okay. Well, I'll sort of answer that question. I guess this is more concluding thoughts. So, obviously we've talked a lot in this session about risks and managing those. So I thought I'd try and end on a more upbeat note. So, from a regulatory perspective, the Australian government and all of the state and territory-based governments, I think, have been trying really hard to develop the digital sector. And I know tech companies weren't that excited with the budget announcements not so long ago. But particularly at the federal level, the government is really trying to make some great changes, including around data use. So Australia's consumer data right, for example, when it's rolled out beyond banking, I think has the capacity to help drive innovation and growth, and obviously tech companies are at the front of that. And the government is also opening up more of its own data to be used for public purposes, assuming they can eventually get that legislation through the Parliament. So as other people have said, we live in really interesting times, and it's really a fantastic time to be involved in the tech sector and helping both public and private entities use the regulatory tools that are available, but also help them develop their services and products.
Perfect. Nitesh, your thoughts?
Yeah, look, it's when it comes to technology, I know this has been a session focused on technology providers, but I think one of the comments, I just wanted to come back to one of the comments I raised very early on, is that the reality is that it's not just technology providers that everything we discuss is relevant to. It's relevant to all businesses now, just because of how embedded and reliant all businesses are on technology and technology providers, and the flow of data. And imagine if the internet went down, for example. So all these proposed changes, all these proposed legislative issues are relevant to all businesses, and it's important that you get things right. I think the biggest takeaway that I'd hope businesses take away from today is around management of expectations. Ultimately, there's a lot of change in this area. It's fluid. Things are constantly evolving, so it's so important to be on top of making sure that you and your client are as best as possible on the same wavelength as often as possible, because that will, in most instances, lead to or mitigate your risks fairly significantly.
Nick, your thoughts?
Well, as I said earlier, I'm really focused on when things go bad, so I can really only offer insight that's more valuable on that part of the process when things have gone wrong. But I think this observation probably has wider significance. What I was going to say is that what lawyers and tech people have in common is that they are both classes of people who spend a lot of time talking in language that nobody else understands. And they talk about stuff that has taken them a lot of training and experience to understand properly. And it takes a lot of skill then to be able to break that stuff down to people who don't understand it intelligent people who don't have your experience or learning, but who you need to understand it. So one of the skills that a lot of us could take on board and do a lot better is learn to explain a lot of these concepts as simply as you can, so that you can get the results you need. From my point of view, if I walk into court to run an argument, I need to be able to break down some fairly complex concepts which I won't necessarily understand very well. I flatter myself that I've got better understanding of tech issues than a lot of barristers, but that's not a very high bar. But even when you are dealing with people who are smart, their intellect is one thing, their understanding in your area is another. So the capacity for people in the IT industry to explain their projects and explain their concepts in a way that the uninitiated can understand is a really useful concept. I think it probably matters at the front end in contract negotiation. It certainly matters at the back end when you're having fights about it. And the last thing I'd say, Ben, and this is not just for business people in this particular space, it's business people across the board, it makes sense to invest in legal advice at the front end. I'm saying that against myself because I earn money from the people who don't get enough legal advice at the front end, but it is important, and it's probably more important in this space than in a lot of others. So those are the things I want to finish with.
Excellent. Final concluding thoughts from me before we go to open Q&A is, if you listen to this, it might sound a little bit negative, but there is, I think, a really important and positive message underpinning all talked about today, which is this is an area that is becoming more sophisticated and more mature. The tech companies are getting better at it, the clients are getting better at it, and that ultimately is going to lead to better solutions, to better tech products, better tech services, and really that's something that is important, but also something that we should all be focusing our mind on to avoid, as Nick said, the types of things that can pay him a great deal of money. So with that in mind, I'm going to hand over to Delvin.
Thank you, panelists. That's been a fantastic and practical session. Although, Nick, when you started off saying the one thing that we have in common, I thought you were going to say intellectual curiosity or something to that effect.
I think that's fair enough too. I thought you were for a moment there going to say good looks, but no, I think that's a perfectly valid observation. So I think, Ben, you're going to become a panelist now. We have a number of open questions that have started to come through. The first set of questions involve the critical infrastructure legislation. And that question comes from Samantha, and Marina also has a question on this. So, Angela, if you could repeat how tech products and service providers could be caught by the new class of data storage or processing assets. I think Samantha recalled you mentioning storing information of 20,000 or more individuals and another element. So she wasn't quite sure what you meant by that.
Sure. So I had the advantage of having a look at the questions, and I've got a copy of the draft bill up. So basically, a critical data storage or processing asset, so that will come within the purview of the legislation, it is a data or storage or processing service that is used for business critical data, and where the end user is also the responsible entity for a critical infrastructure asset. So the business critical data has to fall within a defined definition. So it's either personal information that relates to at least 20,000 individuals, information that relates to research and development in relation to another critical infrastructure asset, or information relating to systems needed to operate such an asset, or just information needed to operate that asset. So, or information relating to risk management and business continuity as well. So you have to fall within that specific narrow definition of business critical data that's in the bill.
Thanks, Angela. And a related question is from Marina. Marina said, it is proposed that universities fall within the critical infrastructure legislation. Do you think universities are aware of the legislation? specifically the consequences of the proposed step and right?
I think they're probably more aware than they might have been a couple of years ago, and also you know, the use of data by universities and the protection of that data has been something that has been a bit of a focus for the federal government, and there's actually not quite sure entirely what they're looking at, but there's a separate sort of inquiry process from one of the parliamentary committees looking at that. So, so I think if you said 3 years ago to the IT department of a major university, well, you know, what regulation are you subject to, they would have sort of looked at you weirdly. But now I suspect they're much more aware of their responsibilities.
So
thanks, Angela.
just one quick thing I'll add there too is I think the university sector is interesting in that they've always been quite mature from the cybersecurity side, but they're also not as joined up as you would ultimately want for someone trying to comply with the critical infrastructure related laws. And that I think will be the biggest challenge for them, making sure they've got the legal, they've got the IT, they've got the governance, they've got the risk people, because the critical infrastructure law runs the gamut. So that's the part that I think they're ultimately going to have to get to grips with in the next 12 to 24 months.
Thanks, Ben, and I agree with that. I think the increasing sophistication is there, especially after the 2020 year that was for universities. Moving on to contracting, we all have had these debates about waterfall contracting and agile contracting. A question from Mark Sables that I'll direct to you, Nitesh. The statement and the question is this: with agile software development, it's hard to set scope up front, but sometimes customers really don't want perceived risk of open-ended time and material projects, so they don't love the sprints. How are companies navigating that in contracting?
Yeah, look, Dalvin, thanks for that question, and it's a tricky one because the more sophisticated your client is, the more understanding they have around what agile means. And this problem that's been raised is particularly prevalent in in scenarios where the client is less sophisticated. And the approach that I've seen that seemed to have worked best is it's that concept of explaining to the client and incorporating it into your agreements what their obligations are under an agile development method, and also making sure you have really robust processes in place from sprint to sprint on what is going to be completed, what is not completed, what that means, and so that effectively it almost creates a scenario where you're making each sprint a contract of sorts. Of course, it's not quite that, but effectively you're just playing it out and explaining to the client, who will effectively be the product owner, that you are engaged in this process, and we have this concept in mind, but that's not to be considered a scope. And again, too often when it comes to the dispute side, it's the list of ideas effectively is perceived to be a scope, when it's really just a list of ideas that needs to be scoped out through the agile development process. So making all of that really clear at the outset is very important. And then we get to that issue of, well, then the client doesn't want to take the open-ended approach, or doesn't want to take on the risks. Well, then the option then is you give the client the fixed price option, where that doesn't happen to the best of your ability, which can be difficult, admittedly, when it comes to a list of ideas. But more often than not, sophisticated providers will be able to go, well, look, these are all ideas, this is very high level, and based on our experience, it's going to be significantly more than the agile method, because part of the agile method is, of course, some of the cost savings and some of the as well as the ability to be fluid, whereas under the fixed price, it's not so. And then once those two options are given, more often than not, if it's properly explained, the agile method is accepted, and then the client does get that better understanding. But yes, it is very much a valid issue, especially in those lower end, the less sophisticated end of the market.
Just one thing to add there too, Delvin. On the agile front, where we certainly see some of the problems are if you're not specific enough around what the obligations are that are sitting on the underlying client. If they are collaborative in the development process, you need to specify that. But you also need to be very, very front foot forward. If something falls down, if something doesn't happen, don't just let that sit in the air for a couple of months. It does require a quite active contract management approach.
Yeah, I agree with that, and Tash, I can relate to what you're saying. That the worst thing that you can do is have multiple individual contracts, but for each sprint, you do end up diluting the main benefit of agile contracting. Can I move us now into the data insight space? And this is a question for all the panelists, and whoever wants to jump in can. The question comes from Atif Sheikh. He says, when does decision support from AI and data insights come from software service provided can be a risk for litigation? How do you overcome contractual agreements when all vendors are doing is building data-intensive platforms and taking no guarantees on the insights or the value derived from these? I'll make a comment on this, and then perhaps I'll throw open to you, Nick, and then Ben. Look, I agree with the sentiment and frustration that Atif is expressing, and it's going to become more prevalent as legislation has come out, data transparency legislation, the data sharing agreements that no doubt many of your clients are starting to see as a result of COVID and in the interest of public health. Ben, could I throw this question to you, and then Nick, then if the other panelists can jump in?
Yeah, I'll cut that in two ways. So I think the cybersecurity reference you made is interesting because everything cybersecurity right now is AI-driven, it's analytics, it's dynamic, it's adaptive. And one of the real challenges I see is that in some cases the AI isn't smart, and it certainly isn't doing anything that's particularly novel. It's just refining a set model or adding in some different assumptions or different bases. So I think the expectation gap around what it is doing and what we say it is doing is going to be a significant live issue. Your question on the vendor side, I think, is also important in that organizations are going to have to get much better in terms of how they challenge and how they understand this particular bit of technology. We see a number of clients now where one of the concerns that's popped into their head is where we're using AI, we're creating a lot of derivatives and other types of assets. Thinking about that, understanding what the implications are. You can only do that if you've got that internal sophistication, but we certainly have to get over this huge amount of trust we place in some of the vendors, because with all of their best intentions and everything that they're doing, you're the organization, you know your risk, you know your profile. You have to be proactive in terms of those types of discussions.
Nick, did you want to make some comments on this?
It's a little outside my comfort zone, to be perfectly frank with you, but I guess the observation I would make, because as I understand the question, at least part of it is to do with the fact that there are relatively big players who can dictate terms on what they're providing. Sometimes that's just how it is, and there's not an easy answer to it. You either buy the product or you don't, and you just have to make that economic decision. In terms of litigating it, there are options if things are really ridiculous, particularly with respect to unfair contracts legislation, but a lot of that is tortuous and it's not often successful. So I think really you're just left to decide, and it follows from what Ben was saying, whether that's the product for you or not, and sometimes it just might be that there isn't something substitutable that you can really switch to, and you might be stuck with what the particular vendor is handing out to you. I'm sorry I can't be more particular than that, but it's a bit outside my comfort zone, as I say.
Thanks, Nick. Look, the other thing I'd like to add on this is you do need to distinguish between the players in this. It'll be the data repository, it'll be the analytics organization that analyzes that data, and ultimately what Ben said, the eventual user of the data, and the risk profile changes across all three. And you also can't underestimate the value of a decision-making framework or decision-making system that will help you bring all that together. I'd like to then move on to insurance. We ended on insurance, and we're probably going to end on insurance with the open Q&A. So a question that I have for you, Ben, and if I can then Petra, get your thoughts on this. Ben and Petra, you mentioned insurers' jaws dropping when they understand what no-code and low-code platform providers are doing. Why?
I'll have the first cut at that, Petra, and feel free to correct me if you're wrong and if you're more generous than some of the other people we speak to. I think the real tension in that low-code and no-code world is exactly what's happening with the product. You are going down to a level of sophistication and a user base that is not someone that you would typically be engaging. Again, you can be dealing with individuals. You've got something that you're trying to push out to as many people as possible, but also how I think a number of those low-code and no-code solutions get integrated in terms of the wider organisation business. So you might have a whole bunch of them packaged together to deliver a service or deliver a platform to clients. And when you start to think of it that way, you almost end up in the worst of both worlds, in that if something goes wrong with the underlying platform, the organisation itself doesn't really have the sophistication to deal with it. You don't really know how the issues are going to be resolved within the low-code, no-code providers. So it just creates a more complex contractual risk process. And I also think it's one where, because it's evolving, we're not sure where a lot of these providers are going to go. We're not sure how the products are going to be used. So again, we're just sitting at that edge of areas of uncertainty, which for insurers can be quite scary.
Yeah, I'd echo that. Insurers are naturally scared of anything that they don't really understand, and anything new. You'll find that there are some at the cutting edge who do make the effort to understand it, and others who'll just shy away because they just don't understand what's going on. And that risk profile where you've got very little control. That makes insurers uncomfortable, and trying to find ways of giving insurers comfort around what controls are in place, and who exactly is responsible for what. I think we'll start to change that, but at the moment, yes, I think most insurers are not that comfortable with something they don't really understand.
Thanks for that. Do the other panelists want to add anything to that? A question came in from Kim. Kim has asked, how will or do insurers of cybersecurity insurance verify the security maturity and controls of the insured organizations? Kim has heard mention made of Essential 8. Well, would reading this be sufficient?
I'm happy to have the first step at this, Petra, rather than pushing you on the spot for the insurer. So the historic answer is insurers have done very, very badly. As if you've ever filled out a proposal form, you'll see the questions are very generic. It really doesn't go to the heart and soul of cyber maturity or cyber resilience. Now what they're relying on is third-party assessment tools, so essentially external scans that they can be used to get some high-level insights, and also really going into granular controls, so patching cadence, process around IT integration, IT migration, issues in terms of how contractual controls are being managed, a lot of focus around their own vendors and their own supply chain. So if you are going through this process, you will get a lot more questions. It's really important that you understand and you answer those questions, because our view is organisations that are seen as being particularly mature in cyber will struggle and may not be able to get the insurance in the coming 12 to 18 months.
I think I'll just step in there and also say I don't know if you've seen this, Ben, but certainly my take is that we're getting to the stage now where the Essential 8 is the starting gate. That's a necessary but not sufficient condition. And I think insurers are beginning to ask more sophisticated questions. Not that the answers necessarily help. We'll frequently get claims where you may have asked a question, I don't know, about two-factor authentication, and that's fine, they do on some of their applications, but not the one that was attacked. So that external validation, I think, that's certainly the way the world's moving now.
And one final comment I'll make there. We had a discussion for one of our large clients a few weeks ago where it turned into a 45-minute chat with the insurers around their IDAM, so their identity access management strategy, whether that was appropriate or fit for purpose. No way that would have happened 12 months ago, but it just shows that those key issues that are driving a lot of the cyber breaches, there will be a lot of focus on that going forward.
Thank you. If I can just end with this final open question to all the panelists. And it's a question that comes from Marina in relation to the threat landscape. Marina asks, how do you think the threat landscape is changing? For example, the prevalence of state actors? And what do you think the role of insurance is in that space? What does it cover? What doesn't it cover?
Do you want me to go again first, Petra?
Yeah. Let's. If I can start with you, Ben, and then go to Petra, Nick, Nitesh, and end with Angela.
So in terms of these type of ransomware and state-sponsored actors, live issue, very much evolving issue, and will be subject to change. Right now, the majority of these are insured. They are covered by insurance policies. There is a carve-out for certain acts of war, and that's got to be something that traditionally is part of either a kinetic war or something that's part of a repeated authorization of government force or language along those lines. What we will probably see in the next 12 to 18 months is there will be a focus on the payment of the ransom amounts themselves, both when they're attached to nation state and otherwise. We will also see, I think, a widening of some of the exclusions. I think the environment that most insurers are terrified about is if we have a large-scale operation that then involves some type of countermeasures in terms of cyber espionage and huge numbers of risk go up. Insurers are terrified of that, so we will see controls around those potential large-scale actions.
Thanks, Ben. Petra, did you have anything to add to that?
Yeah, I mean, certainly the insurers are terrified of the accumulation issues, and they are growing. The biggest problem we have, particularly in relation to that state actor point, is attribution. In a large number of the attacks that we see, you can't, in fact, with confidence, attribute the attack to any particular party. And in that scenario, the burden is on the insurer to establish the war exclusion. As Ben says, there is a war exclusion that applies in certain circumstances, and it's for the insurer to establish that applies. But yeah, I think we are going to see a lot of focus on that as we see more state actors intervening, and a lot of to and fro on that, because I think that although the insurers will want to restrict their liability there, I think there will be a lot of pushback because that's where people need the cover.
Thanks, Petra. And Natasha, if I can move it slightly away from the insurance side of things, how do you see the threat landscape changing? Yeah, look,
it's evolved significantly over the last probably 12 months. I think leading into 2020, there was a perception by some that we wouldn't see so much ransomware, and how different it's been. Ransomware is, I think I've read somewhere it's bordering on a crisis stage at the moment for a number of industries. It's very, very prevalent. It's not just state-sponsored actors. It's threat actors generally. They're becoming far more sophisticated. I think the public is beginning to understand that this is actually a $1 trillion business, and there are some very sophisticated organisations conducting these kinds of frauds and scams. And effectively, what that means is that they're getting more sophisticated. The attacks are getting more sophisticated. Once upon a time, if you had a ransomware attack, it was a bit of a spray and pray kind of approach, where it would be, okay, you got hit. They wouldn't have any real intel on what you do. It was just that your system became encrypted, and then they'd ask for a payment. If you had good backups and the like, you'd be able to get through it. Now they will get into your system. They will look around. They will exfiltrate data if they can. That will be of significance. They will try and spread through your system more generally. Try and hit your backup, then deploy their ransomware payload, and then ask for a payment. Even if you then can recover, they'll go, that's great, but we've got all this fancy data of yours, and if you don't start paying up, we'll start going to your clients and letting them know that we've got it. So it's becoming far more sophisticated, and that I think again, Ben and Petra have kind of set out what it's meaning for cyber insurance. Generally, there's a real concern in the market. There's going to be probably a contraction of terms from what we've heard, and there's going to be some very interesting, I'll call it, new endorsements or provisions in place to try and limit some of the loss that's being suffered as a result.
Thanks, Natesh. And the only other thing I'd probably add to that is, don't forget about the tech players. The threat landscape may not always originate from threat actors, as you would have seen from this morning's CNN shutdown. That was an intranet infrastructure service provider having a glitch, rather than anything more malicious than that. Conscious that it's hitting 7 o'clock, so we might wrap it up there. On behalf of this Australian Society for the Computers and Law, I'd like to personally thank each of the panelists. Thank you, Petra. Thank you, Angela. Thank you, Nick.
Thanks, everyone.
And thank you, Nitesh.
Thank you, absolute pleasure.
For our society, I'd like to especially thank Willis Towers Watson for partnering with us. And then special shout outs go to Ben and Heather and Anthony, who operated behind the scenes to ensure things run smoothly. You will see on the final slide, Heather, if you could click on that we have a range of upcoming events. The next event will be the continuation of our Rules as Code Masterclass and everyone's favorite topics, covering things like future payments, yes, including crypto, smart companies, and the future that we create. I look forward to seeing you at those events. Until then, thank you for your kind attention. My name once again is Delvin Chen. Stay safe, stay well, and stay strong. It's a tough time for everyone. Good night.